Welcome to SDAC, and we're going to get started right now. And I'm going to introduce you to our keynote speaker, our first guest, Joshua Golka. Joshua was appointed Executive Director by the Public Employment Relations Board in October of 2018. Prior to joining PERB, Mr. Golka was previously the California Legislative Affairs Manager for the American Federation of State, County, and Municipal Employees, where he led the organization's state legislative and budgetary strategy. He has nearly 20 years of experience providing political, legislative, and budgetary analysis and representation before California legislature, State Department, boards, commission, coalition groups, and the media. He's a graduate of University of Pacific McGeorge School of Law and holds a Master of Business Administration from Indiana University of Kelley School of Business, as well as Master of Global Management from Thunderbird School of Global Management. So without further ado, I present to you Mr. Golka. The floor is yours, sir.
Thanks, Bobby. I appreciate the invitation this morning. Really happy to be here to get a chance to chat with all of you. As Bobby stated, I've got about 20 years working for public sector labor unions, doing mostly political and legislative work. In addition to AFSCME, I've done work for PEG and CAPS, the State Engineers and State Scientists, SEIU Local 1000, as well as the California School Employees Association. I've done work in California and other states on political campaigns, and then transitioned to PERB back in 2018. Before my arrival, PERB hadn't had an executive director in a number of years. They relied on a board chair when they had one, or the board itself, to administer PERB in its operations, which meant that they couldn't focus on what their real task was, which was to adjudicate cases and come to decisions, which resulted in a really long backlog. So finally, PERB convinced the legislature to fund the executive director position again, and that's why I'm here. I've realized, talking to folks, that not a lot of folks understand who PERB is and what we do. So the Public Employment Relations Board is a quasi-judicial administrative agency that's charged with administering the state's collective bargaining statutes covering public employees throughout the state. That's 14 different statutes. We cover about 2.5 million employees in over 5,000 employers. That includes employees of the state of California, public schools, colleges, and universities, local public agencies like cities, counties, and special districts, trial court employees and trial court interpreters, employees that work for transit agencies like Los Angeles County Metropolitan Transit Authority, Orange County Transit, the BART system, Sacramento Regional Transit District employees, judicial council employees, and then we just recently added childcare providers who are participate in a state-funded childcare and education program. So that's a new group for us at PERB. And the PERB staff, we've got about 75, so we are a small agency in the grand scheme of things. We have a headquarters office in Sacramento. For those that work in Sacramento, you may know that today the power's out downtown. I'm very thankful that today is a telework day for me so that I can join you this morning, because I'm not sure I would have been able to otherwise. We also have regional offices in Oakland and in Glendale. PERB, the way we're organized is we've got the board itself, our Office of General Counsel, we have a Division of Administrative Law, we have a State Mediation and Conciliation Service, and then we have our Division of Administration who helps run things day to day. The board itself is composed of 5 members. All are appointed by the governor and subject to confirmation by the state Senate. Right now we have 4 of those 5 seats filled. Board members are appointed to a 5-year term, with the term of 1 member expiring at the end of each calendar year. That way there's some overlap in their duties. The board has responsibility for just administering all of the statutes under its jurisdiction, but the board itself acts as an appellate body. So as something progresses through our system, they hear challenges to proposed decisions that are issued by PERB staff. Our Office of General Counsel is where everyone's work starts when they come to PERB. Our Office of General Counsel includes our Chief Legal Officer and then the regional attorneys that help folks through the process. This office is responsible for managing any unfair practice charges that come before PERB, representation petitions. They also help with our internal rulemaking process. They analyze legislation that impacts PERB, and then they represent PERB in any court proceedings that we have to go to. After something goes through our Office of General Counsel, we then head through our Division of Administrative Law. That's where all of our administrative law judges are housed. They serve as impartial judges of labor disputes that fall under our jurisdiction. PERB ALJs conduct informal conferences with parties to try to settle disputes before they actually go to a formal hearing. If they can't settle those disputes, then they will conduct a full hearing with presentation of evidence, examination of witnesses under oath, and then they will eventually issue a proposed decision, which has written findings of fact and legal conclusions. Some of you may be familiar with our State Mediation and Conciliation Service, SMCS. They were actually established before PERB. They were established back in 1947 to promote harmonious labor and management relations throughout California, and were added as a division of PERB just in 2012, so not that long ago. Our mediators work with school districts, community colleges, higher education, the state, cities, counties, everyone that's under our jurisdiction, and even some that aren't, to help reach them agreements in collective bargaining when they're in impasse or pre-impasse. They provide mediators for grievance disputes, representation, or elections. Employers or unions who need assistance in setting up and conducting representation elections will turn to SMCS for assistance, and they'll provide it. They also do trainings and other things for local jurisdictions and others who want to know more about interest-based bargaining or how to get along in general, and they serve in that capacity for them. I mentioned our Division of Administration earlier. They're really just there. They're the backbone of PERB. They make sure that our staff have what they need to do their job, and that we have what we need to fulfill our mission. Things like our budget, human resources management, our business services. They were really vital in the transition to telework during the pandemic. And so, a lot of times the support staff and the Division of Administration doesn't get the kudos that they should, but they are vital to the work that all of our staff do. Our jurisdiction. So this is something that folks are often confused about. And so I'll try to help all of you learn a little bit about who PERB is and what we actually do. So the statutes that PERB enforces don't prohibit all acts of perceived unfairness or discrimination against the employees that we cover. Our jurisdiction is really limited to unfair labor practices that violate the acts that we're in charge of. For example, we have jurisdiction over claims by an employee organization, a labor union, that the employer has failed to or won't bargain in good faith, or that they're interfering with the rights of the union to organize under the statute. An individual employee can file an unfair labor practice charge alleging that either the employer or the union has discriminated against that employee for protected activity under the act. So a fairly narrow scope there. An employer can file a charge against a union alleging that the union won't bargain in good faith. But as it relates to a lot of the work of the SDAC and the DACs, our jurisdiction is really just limited to ensuring that an individual has the right to have a union representative present during the interactive process if they want one. And that's about it. We don't have jurisdiction to enforce statutes regarding discrimination generally. So gender, sexual orientation, race, religion, things that would otherwise be covered by the Department of Fair Employment and Housing, the Federal Equal Employment Opportunity Commission, or even SPB, wouldn't fall under our jurisdiction. So it's really just something that's adjacent to what we do. So our major functions really are just the investigation and adjudication of unfair labor practice charges. So someone files a charge with PERB, and then we figure out if there's anything there and come to a decision. We administer the representation process. So as employees decide whether or not they want a union to represent them in their labor relations with the employer, we're involved in that process. We deal with appeals of decisions of our board agents, our regional attorneys. And then our mediation services provided by the State Mediation and Conciliation Service. They can actually offer those services in public and some private settings. And that's really the role that we play. PERB does have its own disability advisory committee. They are small but mighty. As a small agency, they do a really good job, and I think they don't give themselves enough credit for the work that they do to really help us be the best that we can be when it comes to these issues. And so we have a really dedicated core staff, and I think we have probably around 10% of our total staff participate in the quarterly meetings of our DAC. We've got 3 really key committee members of the DAC that help run things on a day-to-day basis. Recently, they've really helped us in a few different ways. We are in the middle of our preliminary rulemaking process on our request for accommodation regulations. They've been really vital in that process, in the drafting of those regulations, particularly in regards to both the definitions that we're using as part of the regulations and the language of the regulation generally. They provided some really great insight and guidance for us there. They recently also arranged for an on-demand screening, virtual screening of the R Word, which for those that don't know is a 65-minute documentary film about the history and kind of lasting implications of derogatory language that was used to describe people with intellectual and developmental disabilities. That was great, well received by our staff, and we really appreciate them coordinating that during the pandemic, which was really useful for us. They've also developed some internal resources so that they are available to our staff that are in these distributed offices, and now with telework kind of distributed statewide, where they house their presentations, their meeting minutes, their bylaws, because they meet quarterly and because the staff is now distributed more widely even than it was before. It's nice to have a digital kind of resource for staff to be able to access on demand when they need it. They were also really vital for us transitioning to telework during COVID, making sure that both the staff knew that they were available for assistance if needed, for accommodations that arose as a result of the transition. Also reminding PERB leadership and our staff that they were there to help us if we needed assistance in guiding through that transition. And I think that made it a lot more seamless when we had to do that and kind of turn very quickly to a more telework environment and then a hybrid environment. They were extremely useful for that and very helpful in that. I just don't think they give themselves enough credit for that. Bobby, you had asked me about our parity rate when we chatted on the phone. I think, for PERB, the most recent number, I think, Bobby, you can correct me if I'm wrong, was around 21%. PERB has a small staff overall. We've got about 75 total. So that number can fluctuate quite a bit, given as people come and go from PERB. And Bobby asked if I knew why our rate was higher than others. I think we investigated it a little bit. I'm not sure I have a good answer. I will say this, our state mediators and conciliators, our attorneys tend to be problem solvers and peacekeepers. And I don't know if that type of work attracts certain individuals to our role. We hope that we've created an environment for folks where individuals are really comfortable disclosing disabilities that they may have on surveys. And so I think that helps. We provide reasonable accommodation language to all of our employees when they start, so that they have the opportunity to let us know if they need anything. Their supervisors, when they start their new hire packet, go over their duty statement with them again, and certify that they've read their duties and won't be needing a reasonable accommodation, or if they do, that they need one. In our recruitment process, we send contact letters to LEAP candidates for our recruitments. If there's any on the certification lists, I'm not sure if that plays a role or not. I wish we had a better grasp of it, but it's something now that we're looking into quite a bit more. And I think just to wrap it up, to see if there's any questions, accessibility for our staff and constituents alike is a priority for PERB. It's very important to our chair. Internally, just acknowledging that the needs of our staff can change, particularly in the hybrid environment, as the transitions happen. PERB's also going through office relocations and things like that. Really just making sure staff's aware of what's there and the resources that are available to them. Externally for our constituents, this can mean something like a regional attorney acting as a scribe for a constituent who couldn't write or type to fill out an unfair practice charge. So even just getting access to PERB at the very outset of the process, really trying to make sure that it's as easy and simple for people to access what we are here for. Or arranging for closed captioning during a virtual hearing with our administrative law judges. So for us, virtual hearings are new. And so ensuring that we're doing things in a way that remain accessible to our constituents and staff and the attorneys and unions that practice before us is really important to us. And we know we're not perfect in that, there's always things we can improve on and work on, but it's something that we are taking seriously, and we're really trying to work on, I would say, daily to get better. With that, Bobby, I think that's the general gist of PERB. If anyone has any questions, happy to answer them. I know Seth Williams, who's on our DAC, is here, and happy to make him answer questions too if anybody has any that I can't answer.
Thank you, Joshua. That was very informative presentation. Not too many people knew about PERB, and they've heard it, I've heard it, but I didn't quite understand the extent of the work that you present. One of the things you mentioned that when it comes to DAC or representing employees, that you advise the employees' rights that they have to have during the interactive process, have representation. Has that been a problem where you've seen cases come up, disputes and issues like that?
We have seen cases, a few, not many. The one that we have seen, or the couple that we've seen, we've just reaffirmed that is a right that employees have, is to have someone with them as part of that process.
You also mentioned that you have this mediation service, SMCS. Now, do they always get involved in mediating issues when people first come? Is that like an alternate dispute resolution program?
Not always. So there's a couple things that happen in our normal unfair practice charge processing. So if someone brings a charge to PERB that they want us to go through, it's actually our regional attorneys oftentimes that will try to mediate that dispute. The State Mediation and Conciliation Service division operates almost outside of our formal unfair practice charge processing, but adjacent to. And so they're available before a charge is even brought, which oftentimes works the best. For us, preferably, if they can go in and train people before there's even anything, that's even better. But if they can get in before the charge is filed or shortly after that, that's great. We sometimes will also bring them in during the formal process if we think that there's an avenue for a settlement and that the sides just need to sit down and talk it out a little more. Sometimes we'll suggest diverting through them, at least temporarily, to see if an agreement can be reached, and if not, then they keep going along with the formal process.
Great. And the other question the comment you made is that the reason why your disability parity rate, and that is the percentage of employees with disabilities working for your organization, is generally or much higher than most organization or state entities. And the reason you cited is you make it known that reasonable accommodation is available. You also make it known that it's, you create a inviting condition for them to disclose if they have disability or not. Specifically, and these are good practices that you just mentioned, and we as a DAC act as a resource for all DACs and overall our membership, which consists of EU officers and reasonable accommodation coordinators, so on. So what exactly do you do, if you were to explain that process when an employee first start during the onboarding with your organization, that you inject these values and culture that makes it possible for them to move forward successfully with the RA process?
That's a great question, Bobby, but I'm not sure we have anything specific. You know, our supervisors aren't instructed to, they're instructed to, you know, they should go over the reasonable accommodation options and things, review the duty statements, but aside from that, I don't think there's anything on, you know, specifically that our staff does. I think for us, it's hopefully just the general environment and culture of PERB that we try to make people comfortable. You know, unfortunately, in some places, and having worked on the advocate side of things for a very long time, there's stigmas attached to employees for various reasons, and some employers aren't as friendly or even just understanding of things, and that can create issues among employees, but also just an unwillingness to share and to ask for help or to ask for an accommodation or to pursue what is available. And so even though an employer may say that something is available to staff, the conditions or sometimes the environment of that employer tells otherwise. And so we try to avoid that, but I don't think there's anything specific we do other than we just try to hire the right people into those positions.
Hiring the right people is very important to be successful at it. You also mentioned that you sent out contact letters to LEAP candidates. So you specifically ask for a LEAP list when you're seeking a person with disabilities to work for your organization. Is that correct?
Yeah, part of our human resources practices, they look at the lists and try, when there is a list for that particular position, try to do outreach. Now, I will say, as far as I'm aware, we don't currently have any LEAP hires, though I do also know that oftentimes folks that are on a LEAP list won't necessarily use the LEAP process to go through the state hiring process. So there's a chance we do have someone that's just didn't use that process for us. And that's where it's interesting. It's hard to kind of track some of those things, but yes, we do try to send out when there is a list available.
And the other thing that I found interesting, you commented on that you get involved when the labor groups and the employer groups reach an impasse, and you get involved during the pre-impasse time, and this is pertaining to negotiation of a contract, a labor contract, I assume. And what exactly do you do during the pre-impasse process to bring the two parties together or find a resolution?
Yeah, that's typically a situation that would be handled by our state mediation and conciliation service, and they go in, and it probably depends on who the parties are in a situation, the relationship between them, and also the mediator themselves. A lot of our mediators come from different jurisdictions, so they were either on the management side or the employee side of some of the jurisdictions, so they have pre-existing relationships. Some of them have been doing this work for a really long time, so they bring a history with them to these discussions and try to see if there's some common ground available to the parties and keep them talking about potential solutions. And sometimes it works and sometimes it doesn't.
Thank you so much. I really appreciate very comprehensive responses you've provided and great knowledge. Do we have questions for Joshua Golka from our membership of the audience? there is a question that I see in chat that says, how often do you have cases that go to a higher court, especially with regard to an employee not in agreement with the settlement offer? Do all cases go through the mediation process?
I'll answer the first one. So I don't have a specific number for an employee not in agreement with whatever the outcome is. Generally, we have some decisions that will be challenged in a higher court. I know over the last 5 years or so, the numbers in the low teens, I think, total for the decisions that have been challenged. And of those, I think 98+% of them have been upheld by our decisions have been upheld by the court, and in the other 1 point whatever percent, there's been minor modifications to the order, so nothing's been vacated or anything. So there's a small percentage that go to court, and then an even smaller percentage that are changed by a court. Do all cases go through the mediation process? No, that's oftentimes up to the parties. We try to offer it to everyone, but sometimes the parties aren't willing for whatever reason. We over the last few years we have invested in training for PERB regional attorneys in the mediation process to allow them to become more comfortable in it. We are now focused more and more about trying to introduce the thought of mediation, not just at the beginning, but kind of at each stage of our process, even something that reaches our full board level. Things that have gotten through that entire process to the board, we've still sometimes recommended and been successful offering mediation in those situations so that the board didn't have to reach a decision. So while it's not a requirement, we do encourage it where possible and at multiple times through the process.
Does PERB DAC have a charter is the question that was asked by somebody on the chat.
I think so. I think Seth answered it in the chat a little bit. I think, PERB's bylaws are on our intranet, and he suggested he could email those that are interested a copy after the meeting.
Great. Thank you so much. Really, this has been very informative discussion. We learned a lot about PERB. Thank you again for coming in and presenting, and please come back and see us soon.
I will do. Thanks for the invitation. I appreciate it.
Thank you.